And sir, you are Natashi Hodo Brown, is that correct?
Yes, sir.
All right. And you can hear me all right, Mr. Hodo Brown?
Yes, sir.
All right. This is the time set for a probable cause conference on Mr. Hodo Brown's case. Ms. Kachukas, how are we proceeding?
Your Honor, it's my understanding that the defense would like to make a motion.
So he is willing to waive his preliminary exam. My understanding the people's offer is going to be to resolve this matter in circuit court with a plea into the mental health court program. But Mr. Hodo Brown wanted me to ask that the court consider modifying his bond to a personal recognizance bond. He is fully connected with CMH services through the ACT program. He meets with them regularly. He will be living with his parents at 3226 West Jolly Road, Lansing, Michigan, 48911. Discussing with the prosecutor, I think one of their concerns is that they would want the court to ensure that he has a tether upon his release to make sure he does not return to the location he has trespassed from. My belief, because he has a payee and I believe receives disability, that he will financially qualify for grant assistance, and so I would not object to a GPS tether, but I would request that the court consider a personal recognizance bond based on his connections with the community and CMH.
All right. Thank you. Ms. Kachukas, what is the position of the people in this matter?
Your Honor, the people will leave that up to the discretion of the court, but the defense is correct. People are requesting a tether because of the potential to return to the original location where he's been trespassed from, and because of the nature of the offenses. If the location where this occurred was an elderly home or living community, so we would just like to ensure the safety of that community.
All right. Thank you. So first thing, let's do the bond, and then he can make a decision based on the bond. I do have a note in the file indicating that this is not my case. This is Judge Buchanan's case, and Judge Buchanan does not want him PR bonded. So I can modify the bond to lower the bond amount. I don't know if that does Mr. Hodo Brown any. I don't know if that helps. But I can modify the bond to make it. It's a 10,000 cash surety bond at this point. So I'm going to deny the motion to reduce bond because I don't know if it matters at this point, because the PR bond is not going to be granted. And then is this going to be left on for prelim, or is this going to be a waiver today?
People would be ready to unconditionally, but I do not know about the defense.
And I certainly, Mr. Nickel, don't want your client making a decision based on his whether it's being left on or things of that nature.
He was, my understanding was he's willing to waive the preliminary exam independent of the bond decision.
Okay, all right. So Mr. Hodo Brown, that's correct. You are going to be waiving your right to a preliminary examination today?
Yes, sir.
All right. Mr. Nickel, may I inquire your client of his waiver of the preliminary examination?
Yes, sir.
All right. Mr. Hodo Brown, you understand that you have a right to a preliminary examination today. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney Scott Nickel, and you will be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding, it is your wish today to waive your right to a preliminary examination, have this case continue to circuit court where negotiations, I assume, will continue. Is that a fair statement, Ms. Kachukas?
Yes, Your Honor, that is.
Mr. Nichols?
Yes, Your Honor.
All right. Is it your wish today to waive your right to a preliminary examination in district court? And you'll have to say a yes or no, Mr. Hodo Brown.
Don't understand.
Do you wish to waive your right to preliminary examination today, or do you wish to have this continued on to preliminary examination next week?
I'll waive my right.
You're going to waive your right?
I believe you said you're going to waive your right, correct, Mr. Hodo Brown?
Yes, sir.
All right. All right. So I believe the waiver of the preliminary examination is being knowing, voluntarily, and accurately made. This case will be waived based on what's indicated on the record And it'll be waived to circuit court. Negotiations are to continue. And I will provide the bind over documentation for the parties to sign. Mr. Nickel, you can sign your name and then on behalf of Mr. Brown based on his request, because he's joining us by Zoom today. So I'll leave that up to you.
Your Honor, can you remind me, what did you set the bond amount at us?
It's still set at the same 10,000 cash surety. Unless you're requesting a modification, which I don't think there's a reason to.
No, I think that's something that can be addressed in circuit.
All right, so bond will be readdressed in circuit court. It sounds like a mental health request. I will indicate the examination was bound. I'm in possession of the district court bind over documentation signed by the parties. The examination is waived on today's date. Bond is continued set at the amount at arraignments. 10%. It's a cash issue, and can be readdressed in circuit court once that judge is selected in circuit court. Is there anything else to come to the court's attention before the court signs the bind over documentation? Ms. Kachukas.
Nothing from the people, Your Honor.
Mr. Nickel.
Nothing from the defense, Your Honor. Thank
All
you.
right, Mr. Hoda Brown, you're all set. Your time in district court is done. You'll be on to circuit court, and you'll get your next date in circuit court from, are you covering for Ms. Wanji?
Yes.
All right.
Sorry.
You'll get your next date in circuit court from Ms. Wanji. You're all set. Thank you, Mr. Nickel.
Thank you, Your Honor.
What?
Yeah.
Yes.
Yeah, no, that's not.
All right, did you want to go?
Um.
All right, Ms. Mays, we'll call your case. You can unmute. Ms. Mays, you can unmute.
Sure.
There you go. All right, so we're on the record in docket 24-03370. That is People of the State of Michigan versus Elizabeth Mays. Will the parties please introduce themselves for the record? Miss Wilson.
Abigail Wilson for the people.
Miss Robinson.
Aaron Robbins, Assistant Public Defender for Ms. Mays.
And ma'am, you are Elizabeth Mays, is that correct?
Correct, Your Honor.
And you can hear me all right, Miss Mays?
Correct.
All right, thank you. This is the time set for a probable cause conference. Miss Wilson, how are we proceeding?
Thank you, Your Honor. Ms. Robinson did inform me that she believes that the Public Defender's Office may have a conflict on this matter. So I believe there will be a request for a good cause adjournment in order to address that. That's correct, Your Honor.
Fair statement, Ms. Robinson. So this case may be conflicted out, and if conflict counsel is sought, we're going to run past the date. Okay. So let's adjourn next week's date for good cause. Conflict counsel may be appointed. And we'll reset. Do you want to reset for PCC again? If conflict
that's a good
counsel, so
idea.
reset for a PCC date.
Yeah, it's a public courtroom.
December 13th at 9 o'clock. All right, so Ms. Mays, there is the potential for a conflict in this case with the public defender's office. That's not your fault. So we're going to adjourn for good cause to December 13th at 9 o'clock, so that can work itself out, and conflict counsel will most likely contact Ms. Mays. Is that a fair statement, Ms. Wilson?
It is, Your Honor. Thank you.
Ms. Robinson?
Yes.
All right. So we've reset this for December 13th at 9 o'clock. Is adjourned for good cause so that no rights will be waived. Anything else for the record in 2403-370, Ms. Wilson?
Not for the people.
Ms. Robinson?
No, Your Honor. Thank you.
All right, Ms. Mays, you'll get notice sent to your last known address on, I think that's on Dorchester is what we have for December
Yeah.
13th at 9 a.m. Okay?
Okay, thank you, Your Honor.
You're all set. Thank you for your appearance today. record in docket 24-03312. That is people of the state of Michigan versus Aaliyah Malilway. Will the parties please introduce themselves for the record? Ms. Kachuka.
Kachukas. Yes, Your Honor. Cassidy Kachukas for the people.
Ms. Schroeder.
Thank you, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Miss, oh my gosh, I'm having a moment here, Miss Malloway. Malloway, yes, there we go. And I would waive her appearance as she is in the Ingham County Jail, but I do not believe her presence is necessary for what we need to do today. Thank you.
All right, and Ms. Kachukas, are you also waiving the appearance of Ms. Malilway? It is my understanding she's in the Ingham County Jail.
Yes,
We
Your
just
Honor.
have not brought her over, and Ms. Schroeder will make sure that she finds out anything that we do at the PCC. Is that a fair statement, Ms. Schroeder?
It is, Your Honor. I've had contact with her both on Polycom and the smart jail mail system. I can let her know.
All right, Ms. Kachukas, how are we proceeding today?
Yes, Your Honor, we will actually be issuing a nollie on this, or nollie crossing on this case because it is tied to another case that is in another jurisdiction. And the other jurisdiction has more of the case.
All right, so this nollie process will be part of a global resolution or a part of your understanding of that they're going forward on the other case, and this case is to be dismissed.
Yes, Your Honor, to just make sure we're in the right jurisdiction.
All
for
right,
everything.
all right.
Yes.
So, are you going to do that at prelim, or are you going to do it before prelim?
I think we're doing it today.
We're ready to do it today.
Okay,
And that is my understanding as well, Your
All
Honor.
right.
It's my understanding that the
If it's Matt's, Mr. Nagel's fine.
I think it's
Miss Holden, I just emailed you, might be numbers fine.
so Ms. Wilson will sign the
Yeah.
nollie process.
Yeah.
All right, so we'll print out a nollie process on this case then. So her non-appearance really becomes unnecessary on this file. I understand, Ms. Schroeder, what that statement.
And yes, Your Honor, I understand exactly why the prosecutor is doing this, as the bulk of this incident occurred in another court jurisdiction.
So the case, I will sign the nollie process.
I can indeed.
They're gonna.
Sorry, I had a
No, you're
moment
good.
there.
And what is the other district that is a part of this?
54B.
54B, East Lansing.
Yes,
Okay.
sir.
Can I approach, Your Honor?
You may. Thank you, Ms. Schroeder. All right, so I'm in possession of the nollie process that has been filed on 24-03312. This case is part of a venue jurisdiction resolution in this matter. I will sign it accordingly on behalf of Judge Buchanan. And at the request of both counsel. Anything else for the record in 24-03312, Ms. Kachukas?
Not for the people, Your Honor.
Ms. Schroeder?
Not for the defense, thank you.
And Ms. Malilway, has she been arraigned on the East Lansing charge?
Yes, it appears as of the
All
13th,
right.
she was arraigned and she has
All
a
right.
bond there.
All right, we should all be set on that, on this probable cause conference. Thank you, everybody, for your appearance.
Thank you.
Thank you, Your Honor.
It would make.
Not saying one way or the other.
24-03093. That is people of the state of Michigan versus David Dodd. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Mr. Goodrich.
Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Dodd, who I believe is over Zoom, but I've not seen him pop up on the screen yet.
And sir, you are David Dodd, and you'll have to unmute. Sir, you are David Dodd, and you'll have to unmute. Mr. Dodd, can you hear me?
I saw him.
He's here. There we go.
go.
So, sir, you are David Dodd, is that correct?
Yes, sorry.
All right. All right, thank you. And you can hear me all right, Mr. Dodd?
Yes,
All right. This is the time set for a probable cause conference. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I believe we're going to leave this step for exam.
All right, is that a fair statement, Mr. Goodrich?
Yes, it is, Your Honor.
All right, we'll leave on for prelim on November 22nd at 8:30. And that would be in front of myself, I believe.
That's correct.
Okay. All right, so we'll leave on for prelim. The probable cause conference was held. And Mr. Dodd, I'll see you next week. That'll be live in person on next Friday at 8:30. All right, sir?
I see that.
All right, anything else for the record in 24-03093, Ms. Wilson?
Not for the people.
Mr. Goodrich?
No, Your Honor.
All right, we're all set. Thank you for your appearance today, Mr. Dodd.
Thanks.
Yeah, he's supposed to email me. So we'll see. I'll let you know.
What's going on, Mr. McCoy? Let's get rid of Judge Buchanan. Let me see on Mr. McCoy.
It's McCain.
Wesley McCoy, you can unmute.
How you doing today?
I'm good. Are you represented by counsel today, Mr. McCoy?
No, I'm not.
All right, stand by and I'm going to call your case.
All right.
All right. And that is on Judge Buchanan.
Yeah.
All right, so we're on the record in docket 24-03361. That's people of the state of Michigan versus Wesley McCoy. Will the parties please introduce themselves for the record? Ms. Kachukas.
Morning, Your Honor. Cassidy Kachukas for the people.
And sir, you are Wesley McCoy, is that correct?
Yes, sir.
All right, and you are not represented by counsel today, is that correct, sir?
Yes.
All right, this is the time set for a probable cause conference. This is the first PCC set in this matter. Ms. Kachukas, how are we proceeding? And I don't know the history of the case, so I don't know. I don't know if Mr. Walker was denied by the public defender's office.
Yes, Your Honor. That's my understanding is he was denied by the public defenders.
Okay, do we have a date of denial on that?
I don't see where they.
So, Mr. McCoy, at this time, you 10/22. So you were denied by the public defender's office on 10/22.
That's right.
And so you've had since that date to get a lawyer for your preliminary examination, and you are unrepresented today. Is that correct?
I mean, yeah. I mean, because I didn't understand why I was told I was paid too much when my lawyer is kind of expensive.
You're gonna have to speak up, sir. I can't really hear you.
I said I was told I was denied for making too much, but as far as I'm like, I didn't.
So did you want to make Did you want to make reapplication to the public defender's office
Yes,
since
I
your
did.
financial status has changed?
Right. Yes.
All right. Do you have a number to contact? What I'm gonna probably do is leave this on and allow him to make a reapplication if his financial status has changed. If not, Mr. McCoy, depending on what the public defenders tells you, you're gonna have to retain your own counsel or
Yeah,
go without counsel. But that'll be Judge Buchanan's problem. That won't be my problem.
Yes.
Right.
So Mr. McCoy, your intent today is to reapply to the public defender's office. Is that correct?
Yes, sir.
All right. do you have a pen or pencil? You can take down their number, because
Yes,
I'll give
I
you
got
their
one.
number right now.
I'm ready.
All right, the public defender of Ingham County's number is 517-679,
679
517-679-2979.
2979. All right.
And you can explain to them that you have made for a previous application, your financial status has changed and you want to make a reapplication.
Right.
You should also tell them that your preliminary examination, so they have this information, is set for November 22nd at 8:30. So it is
You said
set
the
in front of
preliminary-
Judge Buchanan for next Friday at 8:30.
But it said the preliminary is on, well, unless you change it, I was told it was on 11/21 at 10:30.
I can't hear, you're gonna have to restate everything you just said because I can't hear you.
I was told it was on 11/21 at 10:30.
You're gonna call them the day before the prelim?
No, I have the letter saying my preliminary was on the 21st.
It's your prelim, my understanding from the file is your prelim is on November 22nd at 8:30. And your PCC was today's date at 8:30.
Yeah, yeah, well,
But I have your prelim for November 22nd at 8:30. Is that incorrect?
The computer says 11:21 at 10:30.
All right.
yeah, I was told the 21st.
Let's figure that out for sure.
Your Honor, we
Right.
also have it November 21 at 10:30.
All right.
Yeah.
I don't know who wrote the note in here then.
Most Fridays.
That's why I
would
said
be-
unless it was changed, I was told the
Right,
21st
yeah.
at 10:30.
No, I think you're right, but I want to make sure I haven't been giving people the wrong date for next week. And it doesn't look like,
For Buchanan's docket, there was only one, and I think that was the correct time.
I have notice of November 22nd at 8:30. So disregard your notice that you're going to get, because I have notice was sent from the magistrate on November 22nd at 8:30.
Do you know when that was sent? Because we don't.
And November 7th, it was sent on November 7th. Yeah, so that's what I have on the notice.
I'm just looking to see where it actually.
But I think you're right, sir. So let's give you the date. So your date for preliminary examination
Yes,
would be November 21st
at
at
10:30.
10:30.
Yes,
Yeah.
Your Honor.
Right. That's the, so keep on that date, November 21st at 10:30. Your
All right.
notice might say different, but keep it on that date for November 21st at 10:30. All right, sir?
Yes,
All right. And in the meantime, if you get any response from the public defender's office, you should be an attempt to retain your own counsel, but I would reapply to the public defender's office. All right, sir?
yep.
All right. Anything else for the record in 2403361, Ms. Kachukas?
Not from the people, Your Honor.
All right, Mr. McCoy, you're all set. You'll be in front of Judge Buchanan on November 21st at 10:30.
Is that still the probable cause?
That'll be the prelim date. It's just been let for that date. And in the meantime, that gives you another week to try to find either the public defender or retain counsel.
All right, thank you.
All right, you're welcome. Yeah.
On this city prosecutor.
Is he on? Oh, that was. So this is Mr. McCoy. Give me that one back.
Possibly we're looking at Turner's date, he said, 22nd.
It's extremely possible. Yeah.
Return.
Yeah. Yeah. I bet you that was it.
That could be
Yeah.
where the confusion lies.
I had too many files.
That
So,
one should be
yeah.
set for.
All right. So
That
this
set for the
is
22nd.
November. Is it really?
For Turner, it should be the 22nd.
All right, good. So November. Let me give you McCoy and get rid of the file before I start For the PCC. No. That was left on for November 21st. All right, so his notice is right.
Okay.
Yeah,
Just say, I'm not sure how to about it.
no, that's there. It's kind of a surprise, but his notice is correct. He's got it
Okay, perfect.
I did.
and he's reapplied. And there's a note indicating that he was denied public defender.
Okay.
They left the note. All right, so we're on the record. Mark all that out. All right, so we're on the record in docket 24-03361. That is People of the State of Michigan versus Alfred Turner. Will the parties please introduce themselves for the record? Ms. Kachukas.
Good morning, Your Honor. Cassidy Kachukas for the people.
Mr. Palmer.
Good morning, Your Honor. Robert Palmer, the Public Defender's Office on behalf of Alfred Turner. He is in custody. I don't know whether he's on Polycom or not, but if he's not, I'll waive his appearance.
All right, I do not see Mr. Turner on Polycom. There's nobody from the jail here. But Mr. Palmer, you'll let him know, you'll let your client know what we're doing here today.
Of course, and just to be clear, Judge, I've already met with Mr. Turner to discuss discovery, so it's not an issue that we haven't met.
All right. All right, Ms. Kachukas, how are we proceeding at the probable cause conference?
Yes, Your Honor. It's my understanding that we're going to leave this set for preliminary examination, and we're pending a potential district court resolution, but we have to do some follow-up first before that's an option.
And is that a fair statement, Mr. Palmer?
That is a fair statement, Your Honor, and I will certainly discuss that offer and relay that to my client. And as of now, we'll leave it set for the preliminary examination, but I'll advise the people if something changes and they can call witnesses or whatnot.
Perfect. So we've left this on for preliminary examination on November 22nd at 8:30. Said that a lot, and now it's correct. So we will set Mr. Turner, we'll leave it on for prelim next week at 8:30. Anything else for the record in 24-03361, Ms. Kachukas?
Not from the people, Your Honor.
Mr. Palmer?
Not from the defense.
All right, thank you for your appearance today. You're all set.
Thank you.
I should read the name of the file
Yeah,
just when I start
Yeah.
writing it.
That was my fault. I should have kind of wrote the numbers.
Yeah, no problem.
And I didn't for whatever reason. So I apologize.
Someone didn't do Buchanan's jail list, it appears.
Nobody, you don't have any nice highlighting?
They didn't.
No,
they
no,
didn't
no,
order
no
them.
color
They
coding?
didn't even put them on Macaulay on the jail list. That's
Oh,
why
yeah.
the last two defendants haven't been on Macaulay because they didn't do it.
All right, so,
We're running on Dotson.
all right, and that should.
That should be it for Judge Buchanan's docket.
All right, Mr. Dotson, we'll call your case. And you can unmute.
All right.
All right, so we're on the record in docket 24-02868. That's People of the State of Michigan versus DeQuandre M. Dotson. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson to the people.
Mr. Nick.
Assistant Public Defender Scott Nichol on behalf of Mr. Dotson.
And sir, you are DeQuandre Dotson, is that correct?
Yes, sir, I am.
And you can hear me all right, Mr. Dotson?
Yes, sir, I can.
All right, thank you. This is the time set for a probable cause conference. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding that Mr. Dotson wants to find a private attorney. I suggest we leave this set for next week to try to figure out what the progress is there.
And is that a fair statement, Mr. Nichol?
I did speak with Mr. Dotson. He is in the process of trying to retain an attorney. He is actually requesting that the court adjourn the matter to give him time to do that.
I will adjourn the matter, but I will not adjourn it for good cause because he's got some time. If he's willing to waive his right to a prelim within 21 days, he would have some time to seek retained counsel. He has counsel right now.
Yes,
but
he is willing to waive his right to have the exam within 21 days.
All right.
That's fine.
So the court can set the matter out, give him an additional time to find an attorney.
And that's a fair statement, Mr. Dotson. You're prepared to waive your right to a prelim within 21 days so that you can seek retain counsel for this file. Is that a fair statement?
Yes, sir.
All right. Mr. Nickel, may I inquire of your client, Mr. Dotson, of his waiver of the 21-day rule?
You may.
Mr. Dotson, you understand that today you have the right to a prelim within 21 days of your date of arraignment. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney Scott Nickel, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it is your wish today to waive your right to a prelim, not in general, just within that 21-day period, so that you would have the opportunity to retain your own counsel to represent you in this matter. Is it your wish today to waive your right to a preliminary examination within the 21-day period so that you can retain counsel outside of that 21-day period?
Yes, sir.
And Ms. Wilson, do the people also waive their right to a prelim within 21 days?
We do, Your Honor. Thank you.
Okay, and I find the waiver of the 21-day rule to be knowing, voluntarily, and accurately made. And we will reset for prelim. I would guess 3 to 4 weeks out. That would be my guess to get the attorney on board. Miss Wilson would be the contact information. Miss Wilson would be the contact person from the prosecutor's office for any new lawyer who gets on board. And of course, Mr. Nichols would have to make sure that any evidence or any discoveries transferred to your new attorney, sir. So we will reset the prelim and we'll reset it for probable cause conference. Yeah, for PCC. For a new lawyer, I think we should set it for PCC. So we'll reset for probable cause conference for
December 13th.
Not knowing who the attorney is or his schedule, let's leave it on for, and the waiver of the 21-day rule, let's leave it on for PCC on December 13th at 9:30, and then we can set the prelim from there. Because what I'm concerned about is we'll just set it for a prelim date, and then we'll have to move that, and we can, since there's already been a waiver of the 21-day rule. All right.
I would agree with that, especially with how close the December 13th would be to the next day being out.
I just have a feeling we're going to be moving the PCC date for discovery and everything to get to the new council. So
understood.
All right. So Mr. Dotson, it is set for December 13th at 9:30. You'll receive notification at that Grovenberg address at 9:30. And then at the meantime, you should do anything, set it as a priority to retain your own counsel if that's your choosing. All right, sir?
Yes, sir.
All right.
Question,
Anything else?
were you saying that the information that you were saying about my next court date, you were saying that will be mailed to my address? So I'll get it in
once
mail
your attorney
for the
files a
13th?
substitution of counsel, then Mr. Nickel will transfer any police reports or discovery to your new lawyer.
Yes, and now are you still living at the 6103 Grovenberg?
Yes, sir, I am.
Yeah, the court's gonna mail your next notice to you that address.
Okay, thank you. That's what I was asking.
All right,
yes, sir.
perfect. Okay. So you'll get next notification for December 13th at 9:30 at that Grovenberg address.
Okay, thank you, sir. Yes, sir. I understand.
Anything else for the record in 2402-868, Ms. Wilson?
Not for the people.
Mr. Nickel.
Not for the defense, Your Honor.
Okay, we should be all set. Thank you for your appearance today, Mr. Dotson.
Thank you.
Is Mr. Gearing's violation ready and filled out? He's hanging out here for so
Look
long.
here. What case is that?
That's the Aaron Johnson matter.
All right. Let's go on that. Is Mr. Johnson here?
I believe his attorney.
Is Mr. Samuels his attorney?
No, Mr. Samuels is on Richardson.
All right. Ms. Walker, what case are you here on?
Your Honor, I'm here for Miss Greenwood in place of Mr. Oaks.
Okay, so you're here for on the Greenwood case. All right.
Yes.
We're just trying to figure out who's in the room. All right. So yeah, Mr. Gearing, if you can find Mr. Johnson, just let us know.
I believe my client is in the waiting room. And we're ready to proceed.
All right, well, let's identify on the Samsung, on either one of the Samsungs, would you please identify yourself? Either one of the cell phones? On the cell phones, Samsung cell phone 326U or 156U, could you identify yourself?
Emma Hatch.
Oh, Emma Hatz is one, all right. And on the other?
Corey Richardson.
Richardson.
That's Mr. Samuel's client.
All right, and Mr. Samuels, that's your client, is that correct, Mr. Richardson?
That is correct, Your Honor.
All right.
I think we're ready on Richardson.
All right, so let's go on Richardson. All right, so we're on the record in docket 24-03303. That is people of the state of Michigan versus Dakari Richardson. Will the parties please introduce themselves for the record? Mr. Samuels.
Matthew Samuels on behalf of Dakari Richardson. We are both present via Zoom.
Thank you, sir. And then Ms. Wilson.
Thank you, Your Honor. Abigail Wilson for the people. That's fine.
And sir, you are Dakari Richardson, is that correct?
Yes, sir.
And you can hear me all right, Mr. Richardson?
Yes, sir. I can hear you. Fine.
All right, thank you. This is the time set for a probable cause conference. Probable cause conference. Ms. Wilson, how are we proceeding today?
Thank you, Your Honor. I believe we're going to leave this set for preliminary exam. I know Mr. Samuels has emailed me a couple times requesting an offer on this matter. I do intend on relaying one next week.
All right, so we'll leave on for preliminary examination for November 22nd at 8:30. Is that correct?
I believe so.
That is my understanding.
I believe so too. I think the other one was my fault. All right. So Mr. Samuels, that's a fair statement. We're leaving on for November 22nd at 8:30.
Yes, that is fair.
All right, Mr. Richardson, please keep in contact with your attorney, Mr. Samuels, and we've left it on for next Friday at 8:30 for preliminary examination. That'll be live in person on the 6th floor of the City Hall of Lansing. Anything else for the record in 24-03303, Ms. Wilson?
Not for the people.
Mr. Samuels.
Just a quick question, Your Honor. If we happen to work it out ahead of time and don't need to run the exam, can we appear by Zoom?
I don't have a problem with
I have no
preparing.
problem with that.
All right. If there's no adversarial testimony going to be taken, I believe that Zoom would be appropriate for a waiver. So I'll wait to hear from the parties on that. It's live unless I hear from the parties. All right. Anything else, Mr. Richardson, on docket 24-03303?
No, nothing further, Your Honor. Thank you.
All right. We should be all set. Thank you for your appearance today.
Thank you, Your Honor.
All right, Ms. Walker, we'll call your case with Ms. Greenwood. And you'll have to unmute both Ms. Walker and Ms. Greenwood. You'll have to unmute. All right, thank you. So this is the time, this is we're on the record in docket 24-03357. That's people of the state of Michigan versus Chanita Greenwood. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Walker.
Good morning, Your Honor. Shanika Walker on behalf of Ms. Greenwood, who is present via Zoom. The attorney of record is Mr. Michael Oakes, and I'm filling in for him today, and she has no objection to that.
All right, thank you. And ma'am, you are Shanita Greenwood, is that correct?
Yes, sir.
And you can hear me all right, Ms. Greenwood?
Yes, I can, Your Honor.
All right, thank you. This is the time set for a probable cause conference. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I believe we're leaving this up for exam.
Is that a fair statement, Ms. Walker?
That is correct, Your Honor. We do have a conflict with the date that it is set, so we are asking the court for a new date. Mr. Oaks and myself are both in trials and other matters as well too on the 22nd.
All right, so this would be, you both have, you're conflicted for the date of November 22nd, 2024 at 9 a.m. I'm strung by the dates I choose unless Ms. Greenwood is willing to waive her right to a prelim within that 21 day. And then that kind of opens up what dates I can choose. So it's entirely up to you, Ms. Walker.
Yes, Your Honor, she would be willing to waive the 21 days to allow for
right.
a different date.
All right, so Ms. Walker may inquire of your client, Ms. Greenwood, of her waiver of the 21-day rule.
Yes, Your Honor, you may.
All right, thank you. Ms. Greenwood, do you understand you have a right to a preliminary examination today? Or you have a right to a preliminary examination within 21 days of your date of arraignment. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by attorney Shanika Walker, and who's filling in for Mr. Oaks for the Oaks Law Firm, and they would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it is your wish to waive your right to a prelim within 21 days. So you wouldn't be waiving your right to a prelim in general, just within that 21-day period. So we can get a date outside of the November 22nd prelim date so that both Ms. Walker or Mr. Oaks is available to zealously advocate for you in your defense. Is it your wish today to waive your right to a prelim within the 21-day period?
Yes, sir.
All right, Ms. Wilson, do you also waive the people's right to a prelim within 21 days?
We do, Your Honor. Thank you.
Right. I find the waiver of the 21-day rule to be knowing, voluntarily, and accurately made. And then, Ms. Walker, do you have some semblance of how far out we need to go to set the prelim?
Your Honor, we can go to your next available date. I have our calendar pulled up now. I can make sure and then we don't have any conflict.
All right, you'll let us know if that date works for the scheduling. December 12th at 1:30?
December 12th at 1:30? Yes, that works.
All right, so we will set it for December 12th at 1:30. So Ms. Greenwood, please keep in contact with the Oaks Law Firm. We've reset this preliminary examination for December 12th at 1:30. All right, ma'am?
Yes, sir.
And you should get notification sent to the Pacific Avenue address. Is that still a good address for you, ma'am?
Yes, it is.
All right. Anything else for the record in 2403357, Ms. Wilson?
Not for the people.
Ms. Walker?
Not for me, Your Honor. Thank you.
All right, Ms. Greenwood, you're all set. I'll see you on December 12th at 1:30. That'll be live in person on the 6th floor Lansing.
Okay, thank you.
Thank
You're
you.
welcome. You're welcome. All right, and then let's see. This hat was on.
She's in a breakout room.
Yeah, she's in a
We're on the record in docket 2403213. That's people of the state of Michigan versus Patricia DeMond. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson to the people.
Mr. Raleigh.
And Jacob Raleigh on behalf of Ms. DeMond.
And ma'am, you are Patricia DeMond, is that correct?
Yes, Your Honor.
Thank you. This is the time set for a PA 53 or a contempt violation. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I don't have witnesses here today. It appears that there was some kind of mix-up and this case was not put on our witness hotline last night. My officer indicated that he would be here within about 30 minutes to do this, but it's my understanding that Mr. Raleigh has arraignments coming up here around 11, so I don't think we would have enough time to get that done anyway. I'll leave it to the court's discretion.
I have this set for final pretrial on November 18th.
Is it final pretrial or pretrial?
I have an FP final pretrial for November
Okay,
18th.
yeah.
Can you, if need be, can you have your officer here on that date?
I believe so.
All right. So Mr. Raleigh, we can just move this to November 18th.
I would not object to that.
Yeah, that puts it all together. And then we can recognize if you're whether you want to go forward with the file or not. I mean, that would, because you may want, we can put the PA 53 and you'll have a clear indication of the case, so to speak. All right. So we will reset the PA 53. For November 18th at 8:30. And at that time, Ms. Wilson's indicated that she'd be able to talk to her witness, or at least the police officer, to make and to see who's here or who shows up. Because for our final pretrial, I would assume everybody's gotten a subpoena.
At the very least, the complaining witness gets a
At
subpoena,
very
and
least, the complaining witness.
I can be in contact with the officer about whether or not
All right.
he's available.
All right. So ma'am, if you could just treat this, just come to your final pretrial on November 18th, all right? And then we'll see where we go from there. Anything else for the record in 24-03213, Ms. Wilson?
Nothing for the people.
Mr. Raleigh?
No, Your Honor.
All right, we're all set. Thank you for your appearance. So Ms. Hatz is. All right, so we're on the record in docket 24 on two files, docket 24-02654. And 24-03315. That is people of the state of Michigan versus Emma Hatz. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson, for the people.
Mr. Nickel.
Assistant Public Defender Scott Nickel on behalf of Ms. Hatsford.
And ma'am, you are Emma Hatz, is that correct?
Yes, Your Honor.
All right, and you can hear me all right, Ms. Hatz?
Yes, Your Honor.
All right, thank you. This is the time set for a probable cause conference on both these files. Ms. Wilson, how are we proceeding today?
Thank you, Your Honor. It's my understanding we're leaving the separate exam.
All right, so we're gonna leave on for preliminary examination for November 22nd, 2024 at 8:30 on file 24-02654, and we'll leave on for preliminary examination for November 22nd at 8:30 on 24-03315. Ms. Hatch, you'll receive notification at that Bennett Road address. Is that still a good address to receive notification for?
Yes, Your Honor.
All right. So on both files, we'll receive notification for November 22nd at 8:30. That's next Friday at 8:30. That'll be live in person on the 6th floor of City Hall of Lansing. Anything else for the record in docket 24-02654 or 24-03315? Ms. Wilson.
Not for the people.
Mr. Nickel.
Not for defense, Your Honor.
All right, Ms. Hatz, you're all set. We'll see you next Friday at 8:30.
All right, thank you.
Thank you.
Thank you, Your Honor.
Thank you, Mr. Nickel. So we are on the record in docket 23-02319. That is the people of the state of Michigan versus, or city of Lansing versus Aaron Johnson. Will the parties please introduce themselves for the record? Mr. Gehring.
Thank you, Your Honor. Good morning, Deputy City Attorney Joel Gehring on behalf of the city of Lansing.
Mr. Milks.
Hey, good morning, Your Honor. Stephen Milks on behalf of Mr. Aaron Johnson. I'm from the County Public Defender's Office, standing in for Attorney of Record John Lee.
All right, and sir, you are Aaron Johnson, is that correct?
Yes, sir.
Right, thank you. This is the time set for a probation violation hearing or violation of probation. Mr. Gehring, how are we proceeding today?
At this time, Your Honor, I will defer to Attorney Milks.
Mr. Milks.
Thank you, Your Honor. Your Honor, I did have an opportunity to speak with my client regarding his rights to a hearing, as well as going over the recommendations. At this time, we would like to enter a plea at this time to the alleged violations.
All right. So, Mr. Johnson, it's my understanding, you understand you have a right to a hearing in this matter. Do you understand that?
Yes, sir.
You'd be represented by Attorney Stephen Milks, and he would be available to cross-examine any witnesses or cross-examine any witness or contest any charges brought against you by the city of Lansing. So my understanding is your wish today to plead or to admit to the probation violations and go forward with the allocution or with the sentencing. Is that correct, sir?
Yes, sir.
All right. I'm going to have you raise your right hand. Do you solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth on a penalty of perjury? All right. Thank you. So it is alleged that from on October, this is what I'm working from, and then you can correct me. This was a probation officer, Brendan Hanna, submitted a request and summons for probation violation on October 15, 2024. The first allegation is that Mr. Johnson, in a technical probation violation, failed to provide proof of completion of victim impact panel. Sir, did you fail to provide proof of completion of victim impact panel, which would be in technical violation of your probation?
Yes, I did not.
All right. And did you fail to provide proof of completion of substance use education to your probation officer in this matter?
Yes, sir.
All right. Anything towards a factual basis, Mr. Gehring?
Nothing from the city.
Mr. Milks?
No, thanks, sir.
I find the plea to both probation violations to be knowing, accurate, and voluntarily made. And then, Mr. Milks, did you have the opportunity to go through the recommendation or at least address the recommendation with your client?
I did, Your Honor, yes.
All right. Allocution, Mr. Milks.
Thank you, Your Honor. Your Honor, I'm asking the court to adopt the recommendation, it being a suspended sentence and extending probation for 2 months, or at least giving him 2 months additional time. My understanding, Your Honor, is that things go a little bit deeper here. There were some pretty significant health issues that were going on. He's been in contact with his probation officer. To my understanding, his probation officer is fully aware of this. And so it's in conjunction with the fact that he hasn't completed these 2 requirements and the fact that he's had some health issues that I think I didn't get a chance to speak with Mr. Hanna. Unfortunately, I reached out to him, but it's my understanding, kind of reading through everything here, that this is sort of the totality of here that they're working with, and I believe that'd be the basis for the recommendation. So I'd have to support about that.
All right. Anything towards the sentencing, Mr. Gehring?
Leave it to your discretion.
All right. Thank you. I'm gonna based on Mr. Johnson. Is there anything you'd like to say to the court before the court passes the sentence?
No, I really just want to get it over with. The only reason I didn't do it because it was either the lights and the water for my kids or pay for the class.
All right. All right. But I know this is somewhat of a financial hardship. I'm adding 2 months probation for the recommendation. Okay. So Mr. Hanna is a pretty flexible probation agent. All right. He really is. So I'm going to adopt the recommendation. I'm going to place any jail. So I'm going to order 4 days jail, but I'm going to put it in abeyance and suspend it. Okay. So that is the goal. The goal is you don't have to go to jail. Okay. Which is the request, is suspend jail if you don't complete the programs. So if you don't complete the programs, you have, but I'm sentencing jail today, but we're holding it in abeyance. It's kind of an extra incentive not to finish the classes. We want this to be a positive experience, not a negative experience. But so I'm adopting the recommendation of the probation agent. And so I'll state that for the record, this is for the 2 technical violations. The treatment would be an ABR, substance use education, mud victim impact panel, and you can get that through your Mr. Hannah. Testing would be at Aber Health. There's still a current balance of $997.71. 2 months are extended to probation. So probation is extended out to 2 months. I have ordered 4 days in jail to be suspended. So that's placed in abeyance. 4 days placed in abeyance. Or suspended. And then keep in contact with Mr. Hannah, and you should be all set. I'm looking at this as a learning experience, and B, what you're financially able to do. And if you have troubles financially, let Mr. Hannah know. He's pretty easy to work with. That'll keep the ball from getting rolling as far as it did today. All right, sir? All right. Anything else for the record in 23-02319? Mr. Gehring.
No, thank you, Your Honor.
Mr. Mills.
No, thanks, sir.
All right, you're all set, sir. You might want to tell Mr. Hannah what happened. He'll get this addressed, but you should be all set today.
All right, thank you, Ron. Thank you.
Yeah.
Gotcha.
Yeah, the recommendation, months on you, whatever he's
I
got.
thought so, but they always ask.
Judge?
Ms. Perez, I didn't get a recommendation.
I have a Miss Perez and I have.
She's not here, so we're ready to close.
Yeah.
Thank you.
You're welcome. I think you want to look at the recommendation. Miss Jones is the one that is maybe an FTA.
I have not seen her.
All right.
She also has a warrant
Okay.
for a different.
Different file.
And then, so,
Kid, I think.
did you want to go get Gardner?
Yeah, I think so.
All right.
Or Perez.
Or Perez.
You picked it.
You're.
I take
Miss Wilson,
just
Miss-
because I have to leave at like 11:15.
All right, so let's go on Miss
Sorry.
Gardner and then we'll go on Miss Perez.
Mr. Gardner, that's when you say, well, I have to leave in 5 minutes.
I have to leave in 5 minutes.
Come on, get on the ball.
I mean, yeah, if you have some-
She,
I just- we have to do it sooner.
that's a good question.
Do you have the police report? on
Pled guilty
that?
to count.
Yeah, I already gave it to him and everything. It's highlighted.
No objection to 769-4A and count 2, this is an older file.
Yeah.
Is this is an Alderson file. I have no memory of this file. Yeah.
Yeah.
What did she plead guilty to? The count 2 she pled guilty to.
I pled guilty to a DV straight up.
DV
Just
straight
DV
up.
straight up.
Okay,
DV straight.
perfect. Thank you.
No, 769.
She did.
She
have-
did get
Oh, she
spousal,
did?
but she pled straight up to the DV.
Okay.
I need to. Take a moment, and I will be right back.
Oh, perfect. All right, so Gardner and
Gardner, Perez, and Jones are left.
What about Townsend?
That's an arraignment.
Oh, okay.
And I'm, based on my knowledge of Mr. Townsend, I'm guessing that's gonna be a warrant.
Okay.
Just, I wasn't
Just
sure.
saying.
Just saying, just being upfront.
Do you have any opinion on Perez? Did you get to read that recommendation at all?
I did,
So the recommendation is for jail time.
yeah, how long has she been,
Absconded for 4 years.
how long has she been in now?
I'll find that out.
Yeah, because that's gonna be the real question.
They're asking for full jail time on the DV, but let's see what she's got in.
Yeah.
She's been FTA since November of 2020. I'm sorry, January of 2020. So Gardner's going to be a waiver of the prelim and then and then a plea. Is that correct?
That's correct, and he'll be waiving with an added count of aggravated domestic assault.
And so that's count 5.
That'll be count 5, yep.
Count 5. That's domestic 750.81.
That will be an ag, so it's gonna be 750.81A2.
Domestic violence, ag. That's 750.81A2.
Correct. A is an apple? Yes. Thank you. And on the felony packet, I did leave the bond portion blank because I know Mr. Etheridge indicated that he was planning on making a bond motion today. So depending on how that goes,
All right.
we can fill that in.
Did you want to do that before the bind over or it's up to you?
Doesn't matter.
Yeah, I think,
Maybe after the plea.
yeah.
It really doesn't matter, but All right, Mr. Gardner, you can come up here. Right, so we're on the record in docket 24-03172. That is people of the state of Michigan versus John Gardner. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Robinson.
Aaron Robinson, Assistant Public Defender for Mr. Gardner.
And sir, you are John Gardner, is that correct?
Yes, sir.
All right, thank you. This is the time set for was set for felony plea today, but so the first thing today is to bind over the case. So it's in my understanding that we'll be binding over the case first and then be consenting to a felony plea taking in district court. Is that your understanding, Ms. Wilson?
It is, Your Honor. Thank you.
And is that your understanding, Ms. Robinson?
It is.
All right. Mr. Gardner, that's your understanding also?
Yes, sir. Can I speak about something else?
You probably shouldn't, but you, at the advice of counsel could.
We're gonna address that, but it's gonna be after.
All right. All right. And your counsel has indicated that there's going to be a motion for bond on this.
Okay.
All right. All right. So what is your understanding of the plea agreement, Ms. Wilson, for the bind over?
Thank you, Your Honor. My understanding of the agreement is that the defendant will be bound over on the charges in the complaint with an added count of a misdemeanor, domestic violence aggravated. And I provided the PAC code to the court for that. That's a 1 year and/or 1,000. Upon waiver, the offer, and my understanding that will be accepted as a plea of no contest to counts 4, that's the interference with electronic communications, and the newly added count 5, the domestic violence aggravated. There is no sentencing agreement in the matter. There may be restitution owed at the time of sentencing that will be determined at sentencing. And I believe that is the sum of the agreement.
Okay, so the agreement for the bind over purposes is a no contest plea to count 4, a no contest plea to count 5, and that would bind over on counts 4 and 5, and then 1, 2, and 3 would be dismissed upon successful sentencing.
That's correct.
All right. Is that your understanding, Ms. Robinson?
It is.
All right. May I inquire of your client of the waiver of the preliminary examination?
Yes.
All right. Mr. Gardner, you understand you have a right to a preliminary examination day. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney Aaron Robinson, who's filling in for Attorney Etheridge, and she would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding, it is your wish to waive your right to a prelim today, have this case bound over to circuit court, where as we've indicated today, there will be a plea today in front of myself upon consent of the parties. But it's your wish today to waive your time in district court on this file and bind this case over to circuit court only upon what's been stated on the record, which is a no contest plea to count 4 and a no contest plea to the added count 5 of aggravated domestic assault. Is it your wish today to waive your right to a prelim on docket 24-03172? Mr. Gardner, would you prefer to have some time to talk to counsel about this? If you are uncomfortable with the bind over as it is, we can set it for preliminary examination.
Can I say something?
You shouldn't say anything about the case.
All right, what about my procedural due process?
Okay,
I
so it
haven't
sounds
spoke to anybody.
So it sounds
This is my first time speaking.
it sounds like you wish to have this reset for preliminary examination.
I'm not.
Right. So this is not unexpected. All right.
Well,
so let's
not gonna go about the facts of the case because you're being recorded right now.
Yeah, this is all recording, but
I'll take the plea.
Yeah,
I'm not comfortable
I'm-
with this
yeah,
time. I'd like some time.
and this is a no contest plea, so I'm getting uncomfortable
Yeah.
now with the taking of the plea.
I'll
So let's reset for preliminary examination. And that would give Mr. Gardner some time to reassess, because what we don't want you to do is pleading to anything that you're uncomfortable with, all right?
Well,
And you, and you,
Can I speak?
the mere fact that you feel that you need to speak would tell me that you may be uncomfortable.
Can I just say one thing, Your
Sure.
Honor? All right,
Don't discuss the facts of the
I
case.
won't. I agreed. It wasn't aggravated. It was just a domestic too. That's what I thought the agreement was.
All right, well.
That's what I thought.
There's
And
some,
I-
yeah.
And I would plead to that.
Okay, there's been some confusion, so let's reset for preliminary examination. I find the questioning of what the initial consultation was, negotiations. We do have Ms. Robinson, who is, she's filling in for Mr. Etheridge. So I find good cause to adjourn the plea. And we'll set it for prelim. We'll reset for prelim. Preliminary examination. And just so you can talk to, so you're comfortable with what the negotiations are. We'll reset for preliminary examination, and that would be a date of December 5th at 9.
December 12th.
Okay, December 12th at 9 o'clock. So we reset for consideration for the preliminary examination on December 12th at 9 a.m. So I will indicate, I'll scratch out any until further negotiations. Miss Robinson, did you want to be heard on bond prior to the preliminary examination?
Yes, Your Honor.
Okay.
At this time, we'd ask that Mr. Gardner be given a personal recognizance bond. Mr. Etheridge has talked to him. Looks like he has a job that he can be working at in the Diamonddale area and has a place to stay out there as well. He has been in custody since this case has been going on. I believe we're close to a resolution in the matter. So I would ask for a personal recognizance bond.
All right, thank you. Ms. Wilson.
Thank you, Your Honor. This was the request at the probable cause conference. I'll reiterate my argument then. There is an extensive criminal history here, including assaultive history. Mr. Gardner has few ties to the community. He was a resident of Florida until recently. I believe that the bond is set appropriately.
All right, thank you.
Can I say something?
No.
The charges, Mr. Gardner, you can speak, but you shouldn't say anything about the facts of the case.
I won't. Now, I admit, Your Honor, I have my last felony is 2003. Now, I have changed my life. I'm a working citizen. I got a baby on the way. And granted, the witness didn't come in.
Don't talk about the facts.
Okay, not the facts of the case. But I've been in here for 30 days. I got a work truck. I got a place. And this is really, I respect you. I respect her. I respect the judicial system. And I'm just asking for, I will do anything the court asks me to do. I will have no contact with, Miss Davis, and I'll do anything the court asks me to do. I just on my behalf, because,
All right, thank you, sir. I've had a look at the counts. Count one is unlawful imprisonment, which is the higher felony. Assault with felonious assault, which is assault GBH, which is a 10-year. Felonious assault is a 4-year. And then there's a fourth habitual offender notice. And the offender notice has carjacking, burglary, grand theft. So
from 2003.
yes, that's correct.
Right.
2011 is the burglary of an unoccupied structure.
No.
So I don't know. That's all. I'm only telling you what I'm reading.
Okay.
April of 2011 is the offense of burglary of an unoccupied structure. Regardless, I'm going to deny the motion for bond, as I think 20,000 cash surety is probably the right bond that to be set for the protection of the community and the nature of the charges. And I'll deny bond once again to reduce. And then we will set for preliminary examination on December 12th at 9 a.m. Anything else for the record in docket 24? I see here there was not a GPS ordered. And I'm gonna, if Mr. Gardner is able to make bond the 20,000 cash surety, there should at least be a GPS and the no contact as part of the file. And that'd be no contact, that'd be a GPS as in regards to Rakisha Davis. So it'd be a GPS in regards to Rakisha Davis, and that would be with zone notification or victim notification, whichever is preferable. All right, I'll deny bond, and we will see you on December 12th at 9 o'clock. Anything else for the record in 24-03172, Ms. Wilson?
Yes, Your Honor. Just for clarity purposes, the complaining witness did not appear at the last preliminary exam. However, that was because she had to be admitted to the hospital due to infections from the injuries that she sustained during this incident. I have been in contact with her. She's pretty emphatic that she will be here and ready to testify as long as her health permits.
All right, she'll be subpoenaed for December 12th.
She will.
All right, anything else, Ms. Robinson?
No, Your Honor.
All right, that's all for the record in 24-03172. We'll see you on that December 12th date. Thank you for your appearance, Mr. Gardner.
You have any questions? Talk to Mr. Average.
I don't know if you want to wait a second.
No, did you want the packet back?
Yeah. Thank you, Your Honor. I appreciate it.
And then Mr. Milks, are you ready? Ms. Perez.
Yes, we are.
Actually, Wendy, I'll just bring it down with me when I bring Ms. Perez.
All right.
Thank you. I don't know why you would have notes in your same voice. Talk to you when he gets back. Thanks.
All right, so she's gonna hit Ms. Perez when she. Thank you, Ms. Robinson.
No problem.
Or at least I'm trying to let that.
Or you can go and thank Mr. Etheridge. Did you, let's wait on the FDA still after.
Yeah.
We know what, because Mr. Townsend is either really late or not showing up,
The latter.
and Miss Jones is really late or not showing up.
That one I'm not sure.
Once in a while, they're
I didn't
really
know
late.
Finale, finale, so it's not out of the jail. Roger that.
Mr. Milks, how's your wife enjoying Eaton County bench?
It's been interesting since the election and the little village that didn't pass and
Right.
Yeah.
Eaton's
Right,
in trouble.
right.
It's like this amazing little microcosm of what's going on in the US altogether, where everyone thinks it's a really good idea to vote a certain way, but doesn't realize how screwed they just made things, not to get political.
But I mean, the sheriff's department is trying to figure out how to get coverage for the county, and I don't know if it's there.
There's only rules between 6 a.m. and 6 p.m.
Yep.
in Eaton County, so after
That sounds
that,
about
do
right.
whatever you want. That's pretty much what I
Exactly.
heard.
Woo-hoo.
I'm not recommending that to clients, so I don't want to put that on the record.
Luckily, I serve in Ingham County, so Eaton County can do whatever they want.
Yeah, right.
We're not new to.
Oh.
Is she still on the